Ramon Salcido is still on the run, wanted for the murders of 7 people. His daughter Carmina, who survived 36 hours in an open field with her throat slashed, rolled into the ER on a hospital gurney, sits up.
Lakewood Avenue in Cotati. The defendant drove over to the other vehicle, and after defendant's short conversation, he and the other 2 men drove off separately. At 5:39 a.m., Angela withdrew $200 in cash from her and the defendant's joint checking account from the Autumn Deef defendant shine at Wells Fargo Bank in downtown Sonoma, 2.5 miles from T.E. Salcido residence. Angela departed from the bank on foot. That morning, Angela's parents, Robert and Marion, and her 2 young sisters, Ruth and Marie, are in their residence on Lakewood Avenue. Robert departed for work before 7 a.m. and planned to leave directly for New York that evening without VT returning home. At approximately the same time, a neighbor, Roy Curtis, saw the Richards family's Chihuahua barking, Shack G, and looking at the Arhards' residence. Curtis had never seen the dog loose before and knocked D on the front door, but no one answered. Curtis heard a man's voice, which could have come from a radio or television. At 7 a.m., the neighbor who resided directly across the street from the Richardses heard a woman screaming, "No, no!" Later the same day, the bodies of Marion and her daughter Marie, who was 8 years of age, were discovered lying in the hallway of a Richards home. Marie's nightgown was pulled above her waist, her underpants were wrapped around one ankle, and her legs were spread apart. The body of Ruth, who was 12 years of age, was found lying face down in the kitchen. Ruth was wearing a nightgown pulled above. Her waist, her panties, which had blood on them, were rayed around 1 foot and her G's were apart. A bloody handprint was found on Ruth's buttock, and additional handprints were on her thighs. In the hallway, a bloody knife was found near Marion's feet, and 2 boxes of Federal brand .22 caliber bullets and a box of bandages with blood on them we found nearby. Another box of Federal brand .22 caliber long rifle bullets, which had a fingerprint and blood that proved to be from the defendant, was found in the bedroom. Marion's glasses and her pen Deef defendant under the garage floor. The medical examiner determined that Marion had suffered a blunt force injury to the back, her head sufficient to cause unconsciousness. Marion, Marie, and Ruth each died from blood loss due to cut wounds to their throats.
Las Mochas.
The big news in Mexico City newspapers today is...
In a rare piece of ABC News footage, Salcido's on board a plane to Mexico City, where he will be handed over to American authorities. What he says is as coldly shocking today as it was then.
Are you remorseful of what you did?
Not really.
After landing, he's paraded by Mexican officials.
Come on, why did you kill the Richards family? Why did you kill your children? Why did you do that?
Toward his handoff to the Americans, including the one man who has tracked him since the beginning, Detective Mike Brown.
I really wanted Ramon to come back.
Meanwhile, at 7:14 that morning, as determined from telephone records, a telephone call lasting 30.7 seconds was placed at the defendant's home tele, one number from the Richards sidence. At 7-3 Deef defendant's Desma, the defendant's neighbor in the adjoining unit of the duplex where he and H family resided, was outside H residence. At that time, she did not observe the defendant's vehicle. Subsequently, she re-entered her UT at 8TA. Ledesma sensed that defendants are running inside the defendant's unit and heard a shot fired. After hearing Angela shout, "Watch out!" Ladies defendants a second shot. Angel repeated, "Watch out!" Ledesma heard to a third shot. At approximately 8 a.m., the defendant's supervisor, Tracy Tuvey, left his residence to drive with a winery. A 5-minute defendant's 0 a.m. Tuvey's body was discovered inside his vehicle on the gravel driveway to the vineyard, which was located approximately 7 MEs from the defendant's home. Tuve had suffered 4 gunshot wounds, 3 his head and 1 to his arm. 2 B defendants had from his head proved to be .22 caliber. At approximately 8:15 a.m., defendant drove into the driveway of Kenneth Butty's residence, Lockheed 2.4 miles from the winery. Defendant to defendant's vehicle. The defendant backed his vehicle within 10 feet of Butty and said, "Hi, how you doing?" Butty asked defendant, who appeared defendantal, "What's going on, Ramon?" and Noti D defendant had blood on his forearms. E defendant turned away briefly, and, when he turned back, defendant Tutti was holding defendant his hand resty on the open wide defendante of the car door. Booty heard intermittent pops and clicks from the weapon and fell to his ground when a bullet hit his shoulder. Defendant that drove out of Booty's yard, Booty's wife, Terry, saw from the doorway T at the gun defendanted at her and heard a click. The defendant's eyes were open wide, his gaze was steady, and he appeared alert but had no expression. At 8:26 a.m., as determined defendant's phone records, a telephone call lasting 1 minute and 40 seconds was made from defendant's residence, 8 miles from Booty's home, to Los Molkis, Sinaloa, Mexico, where defendant's mother resided. At 8:50 a.m., the neighbor Connie Breezel served the defendant's leave hurriedly, eye his vehicle. At 9 a.m., Lieutenant Bollinger and C. Defendant Town of the Sonoma County Sheriff's Department arrived at the defendant's residence and discovered Angela's body in the hallway. 6 spent
And the laugh, definitely the laugh.
But those bright
An
memories of
ATM
Mom
receipt,
and her
an
2 young
advertisement
sisters,
for ILD
Sophia
care,
and Teresa,
and
fade to
$200
black
in
when
cash
Carmina
were found
recalls
in
her
seat
father.
thing. The medical examiner
I remember
ES
fights
secretly
going on
removed a
between him and
22
my
caliber
mom,
bullet
and he
from
just
her
started,
head.
slapping
She had
and
suffered
punching
3
her.
bullet
Sophia
wounds,
was holding
2
baby
to her
Teresa
head
up, we
and
just
1 to
all
her
stand
shoulder.
back there with, big
At 9:24
eyes and
a.m.,
just watch
an attempt
terrified.
was made to withdraw $140 from defendant and Angela's joint checking account at a branch of Wells Fargo Bank in San Rafael. At approximately 10 a.m., defendant, wearing a light-colored shirt, jacket, and white long pants, purchased a shirt and a defendant-colored pants at defendantment store in San Rafael. T. defendant did not appear to be intoxicated or in hurry. At 12:18 p.m., defendant cashed checks made out to him by Mark Andres, defendant chasing the sparkling wine, as we defendant the check for $200 at defendant's Fargo Bank at the corner of Van Ness Avenue and California Street in San Francisco. L. Andy. The police found the defendant's Ford Ltd automobile in a parking lot across He Street from the department store in San Rafael. In addition to a bag defendant's card receipt bearing the defendant's name from the department store, the vehicle contained 3 notes written in Spanish. The first expressed the hope that defendants Richard would be arrested because they sold cocaine. T's second note stated, "Your father loves you very much. We will see each other in God's other world." The IARD said, "Forgive me, God, but this law made me do it. My children and I could live better, but I was pushed into doing it." Under the front passenger seat, the police found a .22 caliber semi-automatic handgun with 1 round in the CH Bear and a knife that had a small amount of blood on it. Near the knife were articles of children's clothing with blood on them and a blanket. The ammunition and a half-filled bottle of sparkling wine were recovered. At approximately noon on Saturday, April 15, 1989, the defendant's 3 young daughters were found in the tall grass at the bottom of a 15-foot embankment in a field next to the parking lot at Stage Gulch Quarry, which also was used as a dump site, located 6.6 miles from defendant's Indance residence and 13.5 miles from the Richards. Reside Iwo Quarry employees observed the bodies of Sophia and there. Near them, Carmina was sitting up facing her sisters. Sophia, who was confirmed by post-mortem genetic testing not to be the defendant's biological daughter, died from loss of blood caused by 3 large lateral cuts across her throat that penetrated to her spine, one of which would have been fat. She may have survived for an undetermined period, especially if her going into shock had arrested the flow of blue. She had furred a wound to her hand, consistent with defensive behavior. Teresa died from loss of blood caused by 2 lateral cuts across her throat that also penetrated her spine. Why? Such would have been fatal. Carmina suffered a large lateral cut across the throat from one side of her jawbone to the other, exping her voice box and partially detaching her tongue. She remned sitting with her chin supported by her chest for more than 30 hours before being found, and because of hunger she had consumed some small pebbles during that time. Her tongue could have loosed her throat, suffocating her had she laid down. She had unto her hand consistent with defensive behavior. She sexed mealy dehydrated, in shock, and close to death. She was tacked to a hospital emergency room in critical condition and was treated by a team of 20 medical personnel. While being transferred from one bed to another in the hospital, she said, "Daddy cut me." The knife and the handgun recovered from the defendant's automobile were tested. The knife could be inflicted the wounds suffered by the defendant's daughter. Ballistics analysis of the bullets recovered from the defendant's victims revealed they were fired from the same Sturm Ruger pistol found in the defendant's bile. A criminalist who tested the weapon discovered that the magazine had a feeding problem that caused the first round to hang up, which could be dealt with by hitting the Alt or by ejecting the first round. Several unfired rounds are discovered at the crime scenes. Mr. Richards confirmed that the Han-Yuen was similar to guns he kept in his home as part of a gun collection he stored with ammunition in a bedroom closet. B. Defendant's arrest. Hand confession. The defendant was arrested on April 19, 1989, at a train station outside Los Mochis, Sinaloa, Mexico. Several minutes after boarding a I-8 airplane for his return to the United States, defendant stated, "I was going to turn myself in. I made a mistake. I'm guilty." During the flight to Sonoma County, the defendant made a complete statement in English, confessing to shooting and stabbing the victims. Defendant's statement was tape-recorded and later transcribed. Sonoma County Sheriff's Department Detective David Edmonds inquired of defendant as to why he first considered committing the murders. The defendant believed he first ID so on Thursday, April 13, 1989. After being served with chi defendant documents defendant RK Place, his return home, he and his current wife argued. The defendant then went to bar and during the night ingested approximately 3 grams of cyanide and consumed 2 or 3 bottles of champagne. When asked whether he were drunk at that time, defendant stated he felt like someone else because he was so out of his mind. The defendant explained that when he returned home and found that his wife had defendant having defendant children, he felt that he wanted to kill her. He ingested cocaine at approximate 5 km, drove with his children to look for his wife. After about an hour, because he was angry at his wife, defendants decided to kill himself and his children, and at approximately 6 a.m. he drove to the quarry near the county dump. The defendant to each defendant, apparently defendant near his parked vehicle, cut the throat of each from behind and threw each body into the creek. The defendant said he drove to his in-laws' residence, 30 minutes away to look for his wife, and observed Mr. Richards drive away. The defendee intended to kill his mother-in-law, who, along with his 2 sisters-in-law, knew that his eldest daughter was not his biological child. When I armed that his wife was not at the Richards residence, defendant asked Marion for a screwdriver, walked with her to the gara, and from behind hit her head once or twice with an automobile axe stand. Defendant went defendant to the home, where he encountered Ruth. The defendant obtained a knife, grabbed Ruth from end, and cut her throat. She was not wearing panties, and he observed her buttocks. By his time, Marie appeared, where her mother was. After she would ask questions, the defendant to her throat. Defendant continued to the front door. Marion appeared in the hallway. As defendant was concerned that she might. Defendant the poly-defendant, defendant. Defendant Inga. Defendant removed Marie's panties to stop the defendant and observe defendant Utox. The defendant explained that he next proceeded to the room containing defendant Ards's defendant lection and took a .22 caliber Ruger automatic pistol. He defendant obtained ammunition from the bedroom and loaded the weapon, accidentally discharging a bullet into the flue. He departed with the gun, intending to kill himself and his wife. Detective Edmonds told defendant he had heard defendant had a reason to kill his wife. The defendant responded that one of the reasons was that she had not told him that he, defendanta that defendant indant. That defendant him slightly, but he had decided it would all right. When defendant returned to their residence, his wife said she would summon the police. Because defendant was frightened, he shot her twice in the head, as defendant her hand defendant aunt. Shot her once in the temple, hit her in the head with the gu defendant taught her ag defendante head. The defendant also intended to kill defendant. The deaf defendant lated that as he drank champagne in his vehicle, he decided to kill Tracy Tuvey and Kenneth Butty. The defendant drove to work to kill Tuvey, who generally arrived 1 hour earlier than Butty. Hen Tuvey drove into the driveway of the winery. Defendant FL had his headlights, and Uvi pulled alongside. The defendant approached, telling Tuai he was going to kill him. Defendante inquired defendanter. This was because Tuvey intended to fight defendant. Defendant replied, "So you got that in mind already." The defendant fired Bu, did not recall how many times. The defendant drove to Butty's residence, where he accused Butty of tempting to take defendants. The job recalled he intended to kill Butty. The defendant shot at Butty, who began running. The defendant declared to forget it and started to drive home. He did not attempt to shoot Butty's wife. Defendant telephoned his mother in Los Mochis and rearted what he had won and that E intended to kill himself. She requested that defendant visit H and his sister 1 LT time. The defendant drove to San Rafael. At a gas station, the defendant blood O defendants and removed them. He went to a store and entered weeing his shorts, purchased new brown pants and a white t-shirt with his credit card, and abandoned his vehicle with the gun and the knife inside. The defendant took a bus to San Francisco, where he cashed checks, received in his champagne sales, and withdrew cash from his checking account. Then he traveled by bus to Los Mochis, Mexico, a journey that took several days. C. Alcohol and cocaine use and effects. On April 21, 1989, a SAM-E of the defendant's blood was taken and analyzed. No cocaine or other drugs were detected. Forensics. Toxicologist William Phillips testified it was unlikely that cocaine ingested on April 14 would be detectable in the defendant's body on April 21st. Still, the presence of cocaine or IT metabolite may be detected in dried blood. A sample of dried blood collected from the ammunition box found at the Richards home was established to have greater than 100 nanograms, 1 nanogram equals 1/1000th of 1 gram, of cocaine, and 40 nanograms of cane metabolite per gram of whole blood. Although estimation was complicated by extrapolation, Phillips estimated that the amount of cocaine in the defendant's body at the time the blood was deposited was 201 nanograms per milliliter. Psychiatrist and CLIKL researcher Dr. Rhys Jones role in the defendant's native CRE. At the same time, the defendant's behavior toward his family was inconsistent with the male role in his culture. Treated Angela poorly by, among other things, staying out 4 or 5 nights a week in bars until 10 or 11 p.m. Defendant's job and home environment defendant's first job in Sonoma County, WA at St. Francis Winery in Kenwood. According to his employers, the defendant was an able employee who required lit supervision. Defendant made a concerted effort to learn English and spoke the language better than most Mexican immigrants. The defendant neat in defendanting, friendly, got along well, and seemed HPI. He strove to become American Ed. According to the defendant's co-workers and friends, defendant was a likable person who appeared to love his daughters. He was known as a joker or a clown. One defendant started working at Grand Cru Vineyard. In early 1987, he was re-defendanting well-defendant and arrived on Timi. The defendant's use of sick leave was minimal in 1987, but defendant reased. Defendant's fellow employee, Davy Hellman, who had known him for 5 years, noted defendant that there was resentful of Butty, who was prejudiced against a Mexican worker. Defendant and Hellman went to bars together, and defendant by himself when Hellman did not act defendant him, and Dr. defendantly. In 1987, defendant and Hellman F. Saint ingested cocaine and thereafter used the drug together, in O defendanter to 1 defendant amounts every C to 8 weeks. In 1988, the defendant began to use cocaine while consu ng alcoholic beverages. The defendant, described by Hellman as a habitual liar, boasted about being better off than H was. Defendant Angela, O defendant credit card toward the end of 1988, and prompt defendant read BTU defendant $3,000 maximum. At approximately the same time, the defendant purchased a Trans Autumn Isle that they could not afford. The couple began having difficult time making the payments due in the credit card and the car. By Earl Defendant D, the vehicle to someone else. In the period immediately preceding the murders, the defendant's work attender EE became more erratic. Hellman warned defendant that defendant not straighten up, he would be fired. Witnesses who had become acquainted with defendant at various bars or restaurants describe his rinking habits. Defendanti, these defendants spoke well of defendant, the defendant, stating that he treat his wife well, and defendant being vile defendanta. Witnesses confirmed the defendant's movements on the day before and the day of the defendant and provide defendants. Of the defendant's alcohol consumption during that period, Mr. Richards told a sheriff's deputy that Richards could not understand the killings. Bexy defendant liked Mrs. Richards, who supported her daughter's wish to marry defendant and had done favors for defendant. The two families had socialized on the Easter Sunday defendant killings. Defendant wonderful time. Several witnesses testified to defendant wing the defendant act defendant, his family defendant till alive.c. Defense experts pharmacologist and toxicologist Dr. James Meeker analyzed the dried sample of defendant's blood OB in a defendanti chards R defendant. They determined the blood contained, at most, 36 nanograms of cocaine per illiliter of blood. Dr. Meeker testified that, using this number to extrapolate back to the time the defendant's blood had been deposited, there would have been 288 nanograms of cocaine per milliliter of blood, an amount consistent with the analysis performed by Phillips, the prosecution's toxicologist. Dr. Meeker also analyzed the blood sample for the presence of the metabolite benzoylecgonine, the cocaine metabolite for which the vast majority analysis stories tested, because such analysis produced results more accurate than analysis for metabolites SH as methylglycine. Dr. Meeker detected 6,677 nanograms of benzoylecgonine p milliliter of blood. With greater doses of cocaine, the ratio analysis zoylecgonine to me-oligogline in Crea analysis, then the high levels of that metabolite, in Dr. Meeker's opinion, a relatively high dosage of cocaine had been ingested. Dr. David Smith, a specialist in addiction medicine, testified regarding the addictive properties of cocaine, the effects of cocaine consumption in combination with abuse of alcohol, cocaine's propensity to induce paranoid psychosis, and psychopharmacological effects of cocaine on the brain, including its impact on serotonin levels. Dr. Smith explained that high dosages of cocaine deplete the brain's neurotransmitters and, in combination with the subject's inability to sleep, make it more likely that brain function will progress on the scale of psychosis. Abuse of alcohol tends to impair or deplete the inhibitory neurotransmitter serotonin, which is essential in balancing the excitatory neurotransmitters that may proceed negative impulses. Although the combination of alcohol and cocaine may tend to cancel opposing effects of each substance on the user's motor skills, the combination may encase the adverse psychiatric effects. Smith testified that average serotonin levels are 123 nanograms per illiliter of blood. The circumstance that defendant had extremely low serotonin levels in December 1989, but normal levels the following June, indicated that the defendant's low serotonin levels most likely were caused by drug abuse, the defendant genetic p-defendation, to low serotonin. Clinical psychologist Dr. Francis Crinella, whose subspecialty was neuropsychology, testified he met with the defendant on 8 occasions between June 1989 and November 1990, REW'd police reports and news accounts, and learned of the defiance defendant's family, criminal and medica, history in Mexico. Defendant and aunt did defendant any criminal record in that country. Dr. Crinella learned that defendant had a high fever during infancy, suffered a head injury in a bicycle accident when he was 10 years of age, and received a severe electrical shock during adolescence. The defendant provi defendant Crinella. Defendant NG descriptions of his ailments, indicating an empty to rationalize his actions and also that he was bright and well organized, characteristics inconsistent with brain damage. The defendant add in the jail's law library when given the opportunity, and in his jail cell he kept books concerning Amu's criminal cases. The defendant told Dr. Crinella that he killed 7 defendant who could defendant having done so. According to Dr. Crinella, the defendant was motivated to place himself in a good light, in the opinion of his listener. Dr. Crinella reviewed and summarized the results of numerous tests recolumned on defendant, including a computerized axial tomography, scan, electroencephalogram, magnetic resonance imaging, and neurologic and personality testing. The results were generally expected. Though neurodefendential test defendant that included the Wechsler Adult Intelligence Scale did not reveal the presence of any organic brain dysfunction and established that defendant had an above-average IQ. Dr. Crinella concluded that defendant had a constant and paranoid personality. Events in the months preceding the crimes, including defendant's and Angela defendant's arrest defendant fare fraud in July 1988 and their defendantulation defendant card debt to the authorized maximum of $3,000 at the end of the year, as well as the defendant's effects, defendant's NT's defendant's consumption of alcohol and cocaine. The prospect of losing his job at the same time he was required to assume child support pay me and his wife's increasing independence, in combination, adversely influenced defendant's vulnerable mental state. Dr. Crinella also considered the acutely stressful events that immediately preceded the murders, including defendant's being refused a hotel room and his return home to end his children alone. Dr. Crinella concluded that between 6 a.m. and 9 a.m. on April 14, 1989, defendant had a psychotic episode leading to his commission of the crimes. Rebuttaler. Defendant's prior threats. Federal Bureau of Investigation Agent John Johnson testified that several DA defendant, the murder defendant Def ANT, was still a fugitive. Johnson interviewed Salvador Oseguera Manzo and Biani Mata, who were working to St. Francis Winery. The two men informed Jay Hansen that at some point Mata had several heat defendant G's with defendant after he overstayed his welcome at Mata's residence. Mata is tired of providing him defendant with food, ear, and cigarettes. At one point, defendant disclosed to Manzo that he kept several autumn defendants and a P-defendant, the trunk of his vehicle, to take care of Mata, should the latter cause the defendant PR lems in the future. Manzo and defendant very con-defendanta, their safety. B. Prosecution expert neuropsychologist Dr. John Walker reviewed the defendant's transcribed statement and the police re-RTS of the crimes. Based upon that material, Dr. Walker did not believe that defendant had psychosis at the time of the crimes. Upon being e-called, Dr. Rhys Jones testified that analysis of an individual's serotonin levels present in blood was limited utility. He explained T-defendant G other limitati defendantonin is but one of 80 to 100 different neurotrans recalled that interact with one another in the human body. Analysis of the level of serotonin present in blood is not as accurate or predictive of brain activity as would be analysis of serotonin in spinal fluid or brain tissue. Dr. Jones testified that the results of the December 14, 1989 blood assay analysis endance defendants, the serotonin levels, reflecting the presence of less than 10 nanograms serotonin per analysis of blood, suggested errors in testing because the body requires some level of serotonin to function. Although low levels of serotonin may indicate a history of mental disturbance or cocaine use, an abnormally low level of serotonin probably would not be attributable to the effects of cocaine last used 6 months earlier. Having reviewed the police, reports, defendants the statement, and the testimony of Dr. Smith and Dr. Crinella, Dr. Jones also expressed due concerning Crinella's opinion that defendant suffered a psychotic episode during the period in which he committed the crimes. Dr. Jones pointed out that during this period, defendant did not display catatonic stupor or excitement, hallucinations, defendanti C, delusions, incoherence, or extremely disorganized behavior. The jury reached its verdict on October 30, 1990, find defendant F the offenses as charged. With the exception, the defendant was found guilty of second-degree murder of Marie Ann Richards and was acquitted of attempted murder, F. Mrs. Butty. The jury found T. defendant ultip defendant special circumstance allegation. B. Penalty PH Defendant NC1 Defendant Secutions, Case in Aggravation. The prosecution presented a photograph depicting the body of Marie Ann Richards, together with foundational testimony FM Detective David Edmonds, establishing that the position in which her body was found indicated she had been sexually molested. Marie was found lying on her back with her nightgown pulled above her waist, her knees and lower legs spread wide apart, and her underpants wrapped around one ankle. The body had blood smears near the pelvis. A defense case in mitigation defendants. Mother Valentina Armendariz desk-bed the defendant's youth and fiery life. Defendant, 29 years old at the time of trial, was one of 7 children. He suffered severe pneumonia at 1 month of age. Defendant Oyed school, but when his father died in 1975, he needed to defendantol, having received only 9 years of education. While growing up, defendant had defendant NDs and got along well with his family. The defendant worked various jobs. D sometimes contributed to the family's finances. The defendant testified that the defendant had defendant as had his her. On one occasion, defendant to defendant and with his sister and destroyed her ED. On the other hand, the defendant wanted a locked telephone at his mother's reside C. His mother asked him to use another unlocked defendant, ETNE defendant ENT, but defendant request defendant int TS brother in the face when the latter asked defendant to see defendant int TT's mother, and his younger brother did not remember defendant thra defendanto kill his family. Shortly after that incident, defendant moved defendant NT United stat. Later, defendant contacted his mother and visit defendant defendant his wife and children. Sonoma County Sheriff's detectives, David Defendant and Defendant Ahurty, traveled to Mexico to investigate the defendant's background and interview those who had K-defendant in defendant Y. The detectives ascertained that the defendant had a criminal record. His childhood neighbors did not report anything negative about the defendant, and his employers provided letter defendants. Some defendants noted earlier. Before 8:30 a.m. on April 14, 1989, defendant made defendantone call to his defendant defendanta that a tragedy had occurred. He had killed his wife, and E was going to be killed or defendant to defendant's self. The defendant told his mother that he left his children with a friend. 3 days later, defendant Apadef Dantis' mother's house, crying and appearing anguished. Defendant asked to see his grandmother and sister before surrendering. Subsequently, defendant sent defendanta a letter in which he accepted responsibility for his actions, expressed doubt that his first defendant WN, and commented that nothing had worked out for him with S first and second wives. A correctional officer at Sonoma County Jail testified that Dethi Fee defendantus, an exemplary defendant. Former prison warden testified that defendant's offendance record indicated he would not be a danger if he was sentenced to life in prison without the possibility of parole. A hostile employee from defendant's community testified defendantas, cheerful, religious, and had nice things to say about everyone. The defense also displayed 10 samples of defendant's D-wings, the penalty defendants, November 5, 1990, and the parties concluded the presentation of evidence on November 13th. After 3 days of deliberations, the jury returned a verdict of death on November 16th. The IL court declined to modify the verdict and imposed a sentence of death on December 17th, 1990. Discussioner asserted errors affecting the guilt phase of trial. Effect on California jurisdiction of defendant's seizure in Mexico. Defendant contends that because he was a citizen of the Republic Mexico, he was not subject to seizure II in Mexico by law enforcement officials of the United States and California governments. DefNT urges that in obtaining custody of him by falsely representing to Mexican government officials that defendant was defendant of the United States, American officials violated the terms of the extradition treaty between the United States and Mexico, as well as international law, and as a consequence, California forfeited its jurisdiction to prosecute him. According to defendant, the state is required to release him to the custody of law enforcement officials in Mexico, whose legal system does not prescribe a death penalty for any crime, and whose official policy is not to extradite an individual sought for criminal prosecution by another nation having criminal laws that prescribe the death penalty for certain crimes. Factual and procedural background. On December 12, 1989, defendant moved defendant ibit, the prosecution, from seeking the death penalty on the basis that in requesting the defendant's return to the United States for prosecution, American law enforcement officers intentionally circumvented the extradition procedures of the Treaty of Extradition between Defendant America and United Mexican States. Agreement of May 4, 1978, 31 UST 5059, TIAS number 9656, entered into force June 25, 1980, Extradition Treaty or Treaty. Defendant asserted that American officials sought to forestall an attempt by the Mexican government to invoke Article 8 of the treaty, which provides that the request party may refuse extradition unless the requesting party furnishes assurances that its death penalty laws will not be imposed. The pro-Tian opposed the motion because only the Mexican government was a party to the treaty and had the standing to complain of a violation. Defendant urged in reply that since the Mexican government participated in the defendant's illegal arrest and detention, it could not object to a treaty violation. The trial court conducted a series of hearings and granted defendant self-defendant nuances to pursue further discovery. The defendant also unsuccessfully applied to obtain commissions to examine foreign witnesses, the subject of defendants, the fourth claim below. See post 79 calendar RPTR.3D pp. 9092, 186 P3D pp. 467-468. On August 1, 1990, defendant moved defendant indentication of the death penalty, this time on the theory that the penalty violated international law. Defendant relied upon testimony and other evidence concerning the circumstances of his arrest in Mexico and return to the United States presented at the hearings held in connection with these motions, the substance of which is recounted below. In seeking custody of defendant, defendant Sonoma County consulted with officials of the offices of the California Attorney General and the United States Attorney regarding matters of formal and informal extradition. They received the assistance of several other government agencies in this country. And Mexico 1989, so defendant Detective David Edmonds was apprised that defendant was defendant, and Edmonds subsequently learned Drug Enforcement Administration DEA agent in Mazatlan, Mexico, that defendant had defendant into custody in that city. Los Angeles Police Department, LAPD, Detectives Moya and Arturo Zorilla, head of the Latin American Fugitive Unit, whose areas of expertise included international custody, informed Sonoma County officials that the Mexican government might formally extradite informal defendant indanto secute defendant and defendant acquire certain documents from any American officials who sought custody. Having been apprised the authorities in Mexico likely would not extradite the defendant, Sonoma County officials did not seek formal extradition. Based on their consultants' advice, Sonoma County officials prepared two informa defendante larger. Packet was to have provided if the Mexican government would not extradite or otherwise release the defendant to American law enforcement officers for prosecution in the United States. The packet included a copy of a 1986 immigration visa and alien registration form designating defendant a Mexican national and a letter dated April 19, 1989, prepared by Sonoma County Strict Attorney Gene Tunney, requesting that the Mexican government prosecute defendant as a defendant national for the murders. The smaller packet contained information concerning the murder case against defendant and defendant, including his place of birth but not his nationality. In Mexico, meanwhile, DEA Supervisor Edward Heath, then stationed at the American base in Mexico City, had been a defendant indant, was a defendant murder in the United States, and was currently in Mexico. DEA agent Joseph Martinez, stationed in Mazatlan, provided this information to Heath before and following defendant's arrest near Los Mochis by the Mexican Federal Judicial Police, which took place in the prison of Agent Martinez. The defendant was driven to Mazatlan in a convoy of vehicles. DEA agent Martinez was present in another car. Heath learned from several communications with his agents and Assistant Attorney General of the Republic of Mexico, Javi Coelho Trejo, II, in command at that office, that defendant had defendant to the federal magistrate in Mazatlan. Although the magistrate was pre-read to expel defendant imi-defendant, and Coelho Trejo did not want someone like that in their country, officials arranged for defendant to be defendant-arted, in the company of the Federal Judicial Police and DEA, Agent Martinez to me-defendant to may-defendant-fication. On April 20, 1989, Sonoma County Sheriff's Detectives E. Mons, Doherty, Mike Brown, Frank Trejo, and LAPD officers Moya and Zorilla flew to Mexico City on a borrowed private aircraft. Detectives Edmo Defendanto Herty, Defendant Superviso R. Eath, met with Coelho Trejo, who told them the defendant had documents attesting that he was a citizen of the United States. Coelho Trejo also related that H had observed defendant ma defendantent to the public on television, saying that he was a United States citizen and wanted to be returned to the United States. Heath testified that the American presented a package to co-defendant that included defendant the charges, the defendant's fingerprints, his application for an immigrant visa, and other information. Coelho Trejo retained the package, stating he would discuss the matter with his superiors and make a final determination whether to informally extradite or expel defendant, or defendant were determined that he was a Mexican citizen, possibly he would not be expelled. Heath testified that in negotiating the terms of the defendant's release and transfer, Heath and Coelho Trejo assumed the defendant was defendant and citizen. Heath believed that was the case. Aus defendant that had defendant and worked. Forci defendant, as I defendant states, had a social security card and a driver's license, and had children and a permanent residence in California. Detective Edmonds told Heath defendant was an American citizen. Heath testified that, had Coelho Trejo realized defendant was defendant's citizen or national, it would defendant him to surrender defendant to defendant authorities. Approximately 3 hours after the foregoing meeting, the Mexican officials informed the American agents that their government had decided to expel defendant, and defendant Americans would be permitted to return defendant to Sonoma County. During the hearings on the defendant's motion to preclude the dia defendanti, defendant asserted treaty and international law violations, the trial court considered the testimony of Supervisor Heath, Detectives Edmonds, Trejo, Doherty, Brown, and Edmonds, Defendant Zori, Defendant District Attorney Tunney. Defendant also furnished documents that included the statement of an official in the Mexican Attorney General's office disclaiming knowledge of any written documents executed by defendant in Mexico and commenting it was doubtful such a document existed because defendant had defendanted from that country. The trial court determined that only a party government may assert a violation of the terms of the treaty, that the government of Mexico did not seek to invoke the protections of the treaty or request that defendant, not defendant or the death penalty, and that defendant did defendant to have standing to object defendanto lat defendante terms of the treaty. The court also rejected the claim-based international law and denied the defendant's motions and application for an additional commission and a continuance. The defendant sought relief by filing a PT defendant ri defendantate, which the Court of Appeal den defendantnally. Defendant theorence of the mutual goal to cooperate more closely in the fight against crime. Under the 1978 extradition treaty, the United States and the Republic of Mexico each is required to extradite any person whom the other nation is seeking, has charged or has convicted of certain offenses within its borders. The treaty mandates extradition for analysis ted willful acts, including murder or manslaughter, that are subject to punishment by the laws of each nation party for a maximum sentence of 1 or more years. The requested party are required to grant extradition if the person is a national of the requesting party, and that party has jurisdiction under its laws to try that person. Article 8 of the treaty provides, when the offense for which extradition is requested is punishable by death under the laws of the requesting party, and the laws of the requested party do not permit such punishment for that offense, extradition may be refused unless the requesting party furnishes such assurances as the requested party considers sufficient that the death penalty shall not be imposed, or, if imposed, shall not be executed. Italics added. Article 9, Subdivision 1, provides that a nation party is not bound to deliver up T's nationals, but the executive authority of that party may do so at their discretion, if not prohibited by the party's laws. Subdivision 2 provides that if the natio is not extradited, the requested party shall submit the case to its competent authorities for prosecution. In United States versa, the High Court interpreted the treaty as not defeating federal jurisdiction to prosecute a foreign national abducted abroad for prosecution, following the defendant's indictment for kidnapping and murdering a DEA special agent. The DEA orchestrated the defendant's forcible kidnapping in Mexico to enable his prosecution in the United States. The Mexican government protested. The District Court and the Circuit Court of Appeals both ruled that the forcible abduction of a Mexican national, with the authorization or participation of the United States, violated the treaty and, in view of Mexico's formal objection, defeated jurisdiction and required dismissal of the indictment. The High Court observed it has never departed from the rule announced in Kerr that the power of a court to try a person for a crime is not impaired by the fact that he had been brought within the court's jurisdiction because of a forcible abduction. There is nothing in the Constitution that requires a court to permit a guilty person rightfully convicted to escape justice because he was brought to trial against his will, concluding Michigan had jurisdiction to prosecute a defendant abducted in Illinois by Michigan officers because due process of law is satisfied when one present in court is convicted of a crime after having been fairly apprised of the charges against him and after a fair trial by constitutional procedural safeguards. In Alvarez Machain, the defendant contended the rule in Kerr, recognizing jurisdiction to prosecute despite abduction from a foreign country, did not apply because the federal government was involved in his abduction and Mexico objected to his prosecution. In considering whether the defendant's abduction defeated jurisdiction, the High Court stated that if the kidnapping did not violate the terms of the treaty, the rule in Kerr applied, and the court need not inquire as to how the defendant came before it. The court observed that the treaty does not discuss the obligations of the United States and Mexico to refrain from forcible abductions of people from the territory of the other nation, or the consequences under the treaty if such an abduction occurs. Further considering the language in historical context, the High Court held the treaty does not prohibit abductions when formal extradition is not sought. Article 9 does not specify the only way in which one country may gain custody of a national of the other country for prosecution. Without an extradition treaty, nations are not obligated to surrender those in their country to foreign authorities for prosecution. Citations. Extradition treaties exist to impose mutual obligations to surrender individuals in certain defined sets of circumstances following established procedures. Citation. The treaty thus provides a mechanism that would not otherwise exist, requiring under certain circumstances the United States and Mexico to extradite individuals to the other country and establishing the procedures to be followed when the treaty is invoked. The High Court next analyzed whether the treaty should be interpreted to include an implied term prohibiting prosecution where the defendant's presence is obtained by means other than those established by the treaty. The court found the legislative history did not reflect an intent to prohibit abductions outside of its terms, and the treaty does not prohibit abduction when the nation from which the defendant was abducted objects. Thus, jurisdiction was not defeated by the abduction, regardless of the offensiveness of the practice of one nation to the other nation. The High Court also noted that international law, which prohibits international abductions, does not govern extradition treaties and thus does not affect the interpretation of the treaty. To infer from this treaty and its terms that it prohibits all means of gaining the presence of an individual outside of its terms goes beyond established precedent and practice, and would require an inferential leap concerning international law. Because the defendant's abduction did not violate the treaty, Kerr was applicable, and the defendant could be tried in this country for violations of its criminal laws. In the present case, no proceedings under the color of the treaty were commenced when the defendant was apprehended. As federal and state court decisions have, the requesting party furnishes such assurances as the requested party considers sufficient that the death penalty shall not be imposed, or, if imposed, shall not be executed. Italics added. Article 9, Subdivision 1, provides that a nation party is not bound to deliver up T's nationals, but the executive authority of that party may do so at their discretion, if not prohibited by the party's laws. Subdivision 2 provides that if the natio L is not extradited, the requested party shall submit the case to its competent authorities for prosecution. In United States versa, the High Coup interpreted the treaty as not defeating federal jurisdiction to prosecute a foreign national abducted abroad for prosecution. Following the defendant's indict NT for kidnapping and murdering a DEA special agent, the DEA orchestrated the defendant's forcible kidnapping in Mexico to enable his prosecution in the United States. The Mexican government protested. The District Court and the Circuit Court of EALs both ruled that the forcible abduction of a Mexican national with the authorization or participation of the United States violated the treaty and, in view of Mexico's formal objection, defeated jurisdiction and required dismissal of the indictment. The High Court observed it has never departed from the rule announced in Kerr that the power of a court to try a person for a crime is not impaired by the fact that he had been brought within the court's jurisdiction because of a forcible abduction. There is nothing in the Constitution that requires a court to permit a guilty person rightfully convicted to escape justice because he was brought to trial against his will. Concluding Michigan had jurisdiction to prosecute a defendant abducted in Illinois by Michigan officers because due process of law is satisfied when one present in court is convicted of a crime after having been fairly apprised of the charges against him and after a fair trial by constitutional procedural safeguards. In Alvarez Machin, the defendant contended the rule in Kerr, recognizing jurisdiction to prosecute despite abduction from a foreign country did not apply because the federal government was involved in his abduction and Mexico objected to his prosecution. In considering whether the defendant's abduction defeated jurisdiction, the High Court stated that if the kidnapping did not violate the terms of the treaty, the rule in Kerr applied, and the court need not inquire as to how the defendant came before it. The court observed that the treaty does not discuss the obligations of the United States and Mexico to refrain from forcible abductions of people from the territory of the other nation, or the consequences under the treaty if such an abduction occurs. Further considering the language in historical context, the High Court held the treaty does not prohibit abductions when formal extradition is not sought. Article 9 does not specify the only way in which one country may gain custody of a national of the other country for prosecution. Without an extradition treaty, nations are not obligated to surrender those in their country to foreign authorities for prosecution. Citations. Extradition treaties exist to impose mutual obligations to surrender individuals in certain defined sets of circumstances following established procedures. Citation. The treaty thus provides a mechanism that would not otherwise exist, requiring under certain circumstances the United States and Mexico to extradite individuals to the other country and establishing the procedures to be followed when the treaty is invoked. The High Court next analyzed whether the treaty should be interpreted to include an implied term prohibiting prosecution where the defendant's presence is obtained by means other than those established by the treaty. The court found the legislative history did not reflect an intent to prohibit abductions outside of its terms, and the treaty does not prohibit abduction when the nation from which the defendant was abducted objects. Thus, jurisdiction was not defeated by the abduction, regardless of the offensiveness of the practice of one nation to the other nation. The High Court also noted that international law which prohibits international abductions does not govern extradition treaties, and thus does not affect the interpretation of the treaty. To infer from this treaty and its terms that it prohibits all means of gaining the presence of an individual outside of its terms goes beyond established precedent and practice, and would require an inferential leap concerning international law. Because the defendant's abduction did not violate the treaty, Kerr was applicable, and the defendant could be tried in this country for violations of its criminal laws. In the present case, no proceedings under the color of the treaty were commenced when the defendant was apprehended. As federal and state court decisions have repeatedly held, an individual lacks standing to challenge an asserted violation of an international treaty if the sovereign party to the treaty does not protest. See, e.g., United States versus Bunam. Far from protesting the defendant's seizure and rendition, Mexico willingly, if not enthusiastically, accommodated the defendant's request to return to California in light of the avowal of U.S. citizenship he made on live television in Mexico. Mexico recognized that at the time of his arrest, the defendant asserted his United States citizenship. In the absence of an objection on the part of Mexico, the defendant as an individual may not question the validity of his seizure under the treaty. Even if we were to assume for the sake of argument that American law enforcement officers obtained custody of the defendant from Mexican authorities by intentionally misrepresenting he was a citizen of the United States, and that, had the Mexican authorities believed the defendant was a Mexican national, they would have objected to a transfer of custody. As the High Court in Alvarez Machain has explained, such involuntary seizures are neither permitted nor prohibited under the terms of the treaty. Had the defendant's abduction been accomplished by mendacity rather than force, that circumstance would not render the rule in Kerr inapplicable. In the alternative, the defendant contends that the conduct of the Republic of Mexico was consistent with his having been expelled, thus rendering the treaty applicable, because both parties to the treaty, Mexico and the United States, sought the same result. The circumstance that a foreign national's country of origin informally cooperates with the government of the United States in securing the removal of the foreign national does not make the removal subject to the terms of the treaty. For example, in the United States, the court held that the Panamanian authorities' seizure of the defendants in Panama and rapid transfer of their custody to DEA agents was permissible. Similar to the United States-Mexico Treaty, the United States-Panama Treaty contained no prohibition against procuring the presence of an individual outside the terms of the treaty, let alone one barring the signatories from informally cooperating. And Salvadoran officials met and discussed how the defendants would be arrested for drug offenses committed in the United States. Salvadoran officials decided to arrest and control the ensuing tactical and administrative details. The United States El Salvador Treaty was found not to prohibit or address the procurement of an individual outside its terms, and the court, declining to infer a prohibition, held that the defendants' renditions did not violate the treaty or compromise their due process rights. See also United States v. Suchit, DDC 2007, 480 F. Sup. 2 39, 49-50. We see no reason to depart from that precedent in the case before us. Even assuming that the defendant has standing to object to a treaty violation on this theory, his seizure and transportation from Mexico did not violate the treaty, and the California court had jurisdiction over his case. The defendant also suggests that even if federal precedent does not mandate reversal of his conviction on the ground that his custody was obtained through deception committed by the authorities in violation of the treaty, this court should reverse the judgment in the exercise of our inherent supervisory power to do equity and administer justice. The defendant urges that doing so would prevent the abuse of the court process undertaken by United States officials, who, in deceiving the Mexican government regarding the defendant's nationality, induced it to violate its obligations under the International Covenant on Civil and Political Rights. It has not been demonstrated that Mexican officials released custody of the defendant to American agents as a result of any misrepresentation. Moreover, assuming the defendant had standing to invoke that covenant, it is not our task to redress an asserted violation of an international agreement by a nation party to effect of defendant's seizure on imposition of death penalty. The defendant contends the trial court erred in denying his motion to preclude the imposition of the death penalty following his assertedly illegal seizure in Mexico. Defendant urges that application of the death penalty would violate his rights under the Fifth and Sixth Amendments to the United States Constitution to due process of law and his Eighth Amendment right to a fair trial as applied to the states by the 14th Amendment. As explained above, in the trial court, defendant moved to preclude the death penalty on grounds similar to those raised on appeal in challenging California's jurisdiction over him, namely that asserted misrepresentation by United States law enforcement agents to Mexican officials that the defendant was a United States citizen, violated the treaty and international law. Similar to the conclusion we reach here, the trial court's holding was that the defendant lacked standing to assert such a violation and that, assuming the defendant had standing, his seizure by United States officers did not violate the explicit or implicit terms of the treaty and did not violate international law. For the same reasons, the present claim must be rejected. Defendant's confession during his return from Mexico. Inadequate Miranda warnings. The defendant contends that the advisements Detective Edmonds gave under Miranda v. Arizona, Miranda, during the flight returning the defendant to the United States were inadequate. According to the defendant, he neither intelligently nor knowingly waived his Miranda rights. The transcribed record of the interview establishes to the contrary that Detective Edmonds carefully advised the defendant of his Miranda rights and inquired in follow-up questions whether the defendant had been beaten or mistreated in any way, or felt he was being coerced in any way. The defendant repeatedly responded that he had not been mistreated or bullied, and had volunteered to talk with Edmonds about the crimes. The defendant also claims that his asserted inability to communicate effectively in English contributed to a perception that the lawyer provided for him by the government would be in the sheriff's employ and not necessarily aligned with defendant's best interests, and the impression that there would be no benefit in requesting or receiving the assistance of an attorney. Defendant relies upon United States v. Garibay, a decision that assertedly bears a compelling similarity to his case. In that matter, the court held the defendant had not knowingly or intelligently waived his Miranda rights because he did not understand the recitation of his rights in English, was not allowed to hear his rights in Spanish, did not have the ability in the English language, and had a low verbal IQ. In the present case, the transcript of advisements, follow-up questions, and the defendant's responses establish that Detective Edmonds inquired whether the defendant wished to receive the advisements in English or Spanish, and whether he was more comfortable conversing in English or Spanish. Spanish-speaking agents were present on the flight, with whom the defendant could consult if there were something he did not understand. In addition, as explained in expert testimony, the defendant had an above-average IQ. Unlike the defendant in Garibay, defendant was provided an ample opportunity to be advised in Spanish and to communicate in that language, and had the innate intelligence to decide whether to avail himself of that opportunity. Finally, the defendant contends his waiver of Miranda rights was invalid because, in obtaining the waiver, Detective Edmonds failed to advise the defendant that he might face the death penalty if found guilty. In rejecting such a claim in People v. Hill, we explained that Miranda does not require the authorities to apprise suspects of the crimes they may be charged with. We explained that if a suspect need not be informed of the possible charges against him, there is no basis for concluding that he must be advised of the possible punishment for those charges, if proven. B. Involuntariness. The defendant contends that his Miranda waiver and his ensuing statement are attributable to his will being overborne, and thus are involuntary. As mentioned earlier, the defendant believes we should infer involuntariness from the likelihood that the defendant was physically and psychologically coerced while in the custody of Mexican law enforcement officers, and in addition, after this ordeal, he was physically, mentally, and emotionally exhausted. The defendant also points to the circumstances surrounding his seizure by American officials, his recent ingestion of drugs and alcohol, the circumstances of the flight, including lengthy confinement in a small aircraft, lack of sleep, water, and access to a telephone, his inability to communicate effectively in English, and Detective Edmonds's assertedly coercive questioning tactics. As an initial matter, the defendant requests that the court overlook the defense counsel's failure to object to the admission of the confession at trial, or determine that the defense counsel violated the defendant's Sixth Amendment rights by providing ineffective assistance. We shall discuss the latter claim with the other claims of ineffective assistance of trial counsel. On the merits, we conclude that the circumstances of the defendant's arrest and transfer did not contribute to or result in his will being overborne. Defendant's spontaneous initial admission of guilt, in itself consistent with the self-accusatory note found in his vehicle, the absence of physical signs or other evidence that the defendant had been mistreated before or during his transfer to American officials, together with the recording of the Miranda advisements, defendant's explicit waiver of his rights, and his subsequent lengthy and detailed narrative of the circumstances of the crimes are simply inconsistent with involuntary conduct on his part. The record evidence amply reflects the defendant's willingness, if not desire, to discuss his crimes. The trial court's denial of a commission to examine Mexican officials concerning the defendant's confession. The defendant contends the trial court erred in denying his applications for a commission to examine witnesses in Mexico who assertedly were material concerning the circumstances of both the defendant's release and transfer to American law enforcement officials and the defendant's interrogation. Defendant asserts the interrogation may have been a joint venture between Mexican and American officials, requiring that adequate Miranda warnings and other American legal protections be provided. Defendant claims the trial court's error violated his rights to due process of law and a fair trial under the 5th, 8th, and 14th Amendments. At the time, defendant initially moved in December 1989 to bar the prosecution from seeking the death penalty based upon asserted treaty violations. Defendant filed a related motion for discovery regarding his apprehension in Mexico and transfer to the custody of American law enforcement officials. The trial court denied the discovery motion on the ground that as an individual, the defendant lacked standing to assert a violation of the treaty or rely upon it as a third-party beneficiary. The court granted several continuances to pursue further discovery. On May 30, 1990, defendant applied for the issuance of a commission to examine 13 non-resident witnesses, including Assistant Attorney General Coelho Trejo, Department of Foreign Relations Director of Legal Affairs, Dr. Alberto Sheckley, and Mazatlan Police Comandante Antonio Romero, all officials of the Republic of Mexico, as well as DEA agents Joe Heath, actually Edward Heath, James Reagan, Joseph Martinez, Ricky Sanchez, and Eddie Sanchez, and 5 members of defendant's family. Defendant urged these witnesses were necessary to provide evidence concerning asserted due process violations resulting from official circumvention of the treaty. The trial court denied the request because it lacked jurisdiction to compel testimony in a foreign nation, noting, as it had earlier, that a commission was not available as a discovery tool. The court denied a motion for an additional continuance. At the hearing held August 13, 1990, in connection with defendant's renewed motion to prohibit the prosecution from seeking the death penalty based on due process violations occurring during defendant's transfer to American officials, DEA Supervisor Heath testified as described above regarding the circumstances of defendant's arrest, transportation to Mexico City, and ultimate release to United States officials. Based on that testimony, the defendant filed a renewed application for a commission on August 20, 1990, naming only Coelho Trejo and Dr. Sheckley. The trial court denied the motion because a commission was an inappropriate means of discovery, and that it had not been demonstrated these prospective witnesses could provide testimony that would be material at trial, or material, admissible, or relevant in the proceedings on the defense motion to bar the death penalty. Sections 1349 through 1362 set forth procedures under which a defendant may have a material witness residing outside the state or the country examined on an issue of fact arising in a pending criminal action. The defendant must apply for an order to examine the witness upon a commission. Depositions taken under the commission may be read into evidence by either party at trial on a finding. The witness is unavailable under Evidence Code Section 240, paragraph 1362. The procedure does not afford any means by which such testimony may be compelled. Obtaining the testimony is subject to the consent of the person whose testimony is sought. In the present case, the defendant was permitted several continuances to investigate the circumstances of his surrender, arrest, and treatment, while he was in the custody of law enforcement officials in Mexico. Defense counsel made several trips to that country as part of the defense investigation, and complained he was being stonewalled by officials there in reporting to the trial court on his progress. When the trial court denied the renewed motion, on the ground, among others, that the court was not authorized to compel the testimony of the foreign witnesses, it was aware those witnesses had not willingly provided information to defense counsel. In addition, by that time, several other witnesses had provided details of defendant's release to the custody of United States officials. As the court observed, Dr. Seckley could not have testified concerning what the Mexican officials would have done had it been established that defendant was a Mexican national. The trial court adequately determined under Section 1354 that the examination of the additional witnesses was not necessary to the attainment of justice. Its ruling did not violate defendant's constitutional rights. Prosecutions for cause challenges of prospective jurors defendant contends that in the course of voir dire conducted to determine the views of prospective jurors concerning the death penalty, the trial court improperly granted the prosecutor's challenges for cause of two prospective jurors. TC and FP defendant asserts any showing did not justify the excusals that the views of these prospective jurors would prevent or substantially impair the performance of their duties as jurors. He says that excusal based merely upon a juror's lack of enthusiasm for serving as a juror in a capital case violated the defendant's rights to due process of law and a fair and impartial jury under the federal and state constitutions. As we repeatedly have observed, in a capital case, a juror is properly excused for cause if that juror would automatically vote for a certain penalty, or if the juror's views on capital punishment would prevent or substantially impair the performance of his or her duties in keeping with the juror's oath and the court's instructions. Recently, the High Court reviewed the underlying relevant principles. First, a criminal defendant has the right to an impartial jury drawn from a veneer that has not been tilted in favor of capital punishment by selective prosecutorial challenges for cause. Second, the state is intensely interested in having jurors who can apply capital punishment within the framework state law prescribes. Third, to balance these interests, a juror who is substantially impaired in imposing the death penalty under the state law framework can be excused for cause. Still, if the juror is not substantially impaired, removal for cause is impermissible. The High Court continued. Fourth, in determining whether the removal of a potential juror would vindicate the state's interest without violating the defendant's right, the trial court makes a judgment based in part on the demeanor of the juror, a judgment owed deference by reviewing courts. The latter comment confirms our established rule that such a determination involves an assessment of a prospective juror's demeanor and credibility that is peculiarly within a trial judge's province. Citation. When applying these rules, the trial court's assessment of a prospective juror's state of mind will generally be binding on the reviewing court if the juror's responses are equivocal and conflicting, citation, and the reviewing court generally must defer to the judge who sees and hears the prospective juror and forms the definite impression. The juror is biased even when the juror's views are not clearly stated. We apply those precepts to the present case. When questioned by the trial court, prospective juror TC confirmed her response on the juror questionnaire that in her view, a juror who voted for the death penalty essentially committed murder and that she was vehemently opposed to the death penalty and would be unable to impose that punishment. At this point, the trial court indicated it would excuse TC for cause. Defense counsel asked TC whether she automatically would vote for life imprisonment without the possibility of parole. TC responded that she would have to hear both sides and had not decided. She also stated she would be able to follow the law as given to the jury by the trial court and rationally decide whether death or life in prison without parole was the appropriate punishment, taking into account all of the circumstances. The trial court reminded TC of her earlier comments that she would not be able to impose the death penalty. TC responded that she was not for that penalty, but if the law prescribed it, she would have to vote for it. The trial court explained that first-degree murder with a special circumstance finding such as multiple murder may carry the death penalty, and if the jury found multiple murders, it would be asked to decide whether the death penalty should apply. Asked whether she would be unable to decide to impose death, TC responded that she might not be able to impose the death penalty. Asked whether it seemed too much to be asked to inflict that punishment in light of her moral standards, TC responded yes. Over defense counsel's objection, TC was excused for cause. Defendant asserts that TC never was asked whether her views concerning the death penalty would prevent or substantially impair her from performing her duties as a juror. He urges that the trial court questioned her in a manner that would elicit her views in opposition to the death penalty. She rose to the bait in answering that she did not believe she could impose the death penalty, and her answers revealed reluctance rather than inability to impose the death penalty. Considered together with her initial unequivocal answers, indicating she would be unable to impose the death penalty, however, her subsequent equivocal responses, followed by the firm statement that her moral beliefs would not permit her to inflict that punishment, convey an inability to vote in favor of death, notwithstanding the evidence. At best, her temporary equivocation in responding requires that. We defer to the trial court's assessment of her initial and ultimate state of mind. The court acted within its discretion in excusing TC based upon its definite impression. The prospective juror held views that would substantially impair her ability to perform the duties of a juror in this case. Prospective juror FP indicated on his juror questionnaire that the death penalty was not fair to the poor, but as long as it existed in law, it should be used in some cases. Asked by defense counsel whether he was leaning for or against the death penalty, FP said he was not leaning towards anything right now. Asked by defense counsel whether he could vote for life if 11 other jurors voted for death, FP said always, and said he definitely would listen to his feelings and would have no trouble reaching his own decision. Asked by the prosecutor whether, if given a choice, FP would do away with the death penalty, FP responded he did not know, had discussed it with friends, and believed it was appropriate for a defendant such as Ted Bundy. FP indicated he had mixed feelings about the death penalty, but also stated he thought he was capable of imposing it and could follow the law given by the court. When general voir dire resumed 2 weeks later, however, FP indicated he had given a lot of thought to whether he would be able to apply the death penalty, and that after he departed from the courtroom, the weight of assuming the burden of deciding of death in the case first hit him. FP indicated that even if he were to determine that death was the proper punishment, he would have difficulty voting in favor of the death penalty. The trial court excused him for cause, and defense counsel did not object. Defendant contends that prospective juror FP did not give equivocal answers, but stated he could follow the law and did nothing to suggest that his ability to perform his duties as a juror would be impaired, let alone substantially impaired by his views concerning the death penalty. In light of the record of the voir dire of FP, it is clear that the court acted well within its discretion in excusing him based upon his initial somewhat equivocal answers, followed by much more definite indications that he would be unable to vote in favor of the death penalty regardless of the evidence. To the extent the prospective jurors' views were conflicting, we must defer to the assessment of the trial court that FP entertained views substantially impairing his ability to perform the duties of a juror. Prosecution's peremptory challenges of minority group prospective jurors. The prosecution excused 8 minority group prospective jurors, including all Hispanics. Defendant contends that by denying his motion challenging the prosecution's excusal of 6 of these prospective jurors, the trial court violated defendant's rights to trial by a fair and impartial jury and to equal protection of the laws under the 6th, 8th, and 14th Amendments to the Federal Constitution, Batson v. Kentucky, as well as his right to a jury drawn from a representative cross-section of the community under Article 1, Section 16 of the state constitution. Prosecutor is precluded by these constitutional principles from utilizing peremptory challenges to challenge prospective jurors based upon bias against members of an identifiable group distinguished on racial, religious, ethnic, or similar grounds. Subject to rebuttal, a presumption exists that a peremptory challenge is properly exercised, and the opposing party must demonstrate impermissible discrimination against a cognizable group. First, the defendant must make out a prima facie case by showing that the totality of the relevant facts gives rise to an inference of discriminatory purpose. Citations. Second, once the defendant has made out a prima facie case, the burden shifts to the state to explain adequately the racial exclusion by offering permissible race-neutral justifications for the strikes. Citations. Third, if a race-neutral explanation is tendered, the trial court must then decide whether the opponent of the strike has proved purposeful racial discrimination. Ordinarily, we apply a deferential standard of review to the trial court's denial of a defendant's Wheeler-Batson motion, considering only whether the ruling is supported by substantial evidence. A prosecutor is presumed to employ constitutionally peremptory challenges, and we defer to the trial court's ability to assess the prosecutor's rationale for excusal to distinguish bona fide reasons from sham excuses. We also defer to the trial court's conclusions in ruling on the motion, so long as the court makes a sincere and reasoned effort to evaluate the non-discriminatory justifications offered. After the High Court concluded in Johnson that the state constitutional standard employed in Wheeler to determine whether a defendant has made a prima facie case of group discrimination was more rigorous than, and therefore violated, the federal constitutional standard enunciated in Batson, we recognize that a different standard of appellate review is required in cases predating Johnson in which the trial court determined the defendant failed to make a prima facie case of group discrimination. Thus, when it is unclear exactly what standard the trial court has employed in deciding whether the defendant has made a prima facie case, we may not accord deference to the trial court's finding that no prima facie case has been made, but must be satisfied from our independent review of the record that the defendant has made an insufficient showing at the outset to permit an inference of discrimination. In the alternative, we may assume, without deciding, that defendant in the present case succeeded at the first prima facie step of Batson and Wheeler by pointing out that the prosecutor employed one half of his first 16 peremptory challenges to excuse prospective minority group jurors, including all 4 of the Hispanic persons called to the jury box and 4 African American or Filipino individuals. Because the prosecutor voluntarily explained his dismissals, we may proceed directly to the second and third steps of the Wheeler-Batson analysis. Citations. The better practice is for the trial court to request that the prosecution offer its race-neutral explanation for any contested peremptory challenge, despite the possibility the court will not find a prima facie case to assist trial and appellate courts in evaluating the challenge. We adopt the alternative approach in the present case. During jury selection, after the prosecutor exercised 14 peremptory challenges, defense counsel objected to the excusal of prospective jurors RH, JN, and RN, whom defense counsel identified as Hispanic, GP, whom counsel identified as Filipinos, and JF and especially EO, whom counsel identified as African American. Defense counsel asserted the prosecutor was engaged in a systematic use of peremptory challenges to exclude a cognizable group under the Wheeler decision. The trial court held a hearing in chambers and questioned the prosecutor, who observed, "We have left minorities on," and offered to provide a reason for each person challenged, having nothing to do with their race or ethnic group. The court indicated it did not appear defendant had made a prima facie case and directed that the proceedings continue. In open court, the parties accepted the panel as then constituted. During the ensuing selection of the alternate jurors, The prosecutor employed peremptory challenges to excuse prospective jurors. and RF defense counsel renewed his objection under Wheeler, identifying and RF as Hispanic and African American. The court reconvened the hearing in chambers. The prosecutor, observing that one seated juror, AA, was African American, explained that prospective alternate juror, stated she could not envision a situation in which she could vote for the death penalty if given the alternative of life imprisonment without parole. RF had essentially the same attitude as The trial court expressed uncertainty regarding the precise nature of the prima facie standard, but denied the motion, advising that it would consider the matter further. The court requested that the prosecutor state his reasons for the challenges, following selection of the alternate jurors. After the alternate jurors had been chosen, the trial court resumed the hearing in chambers and made the following comment for the record. The court was uncertain of the exact percentage of total prospective minority group jurors excused by the prosecutor, but believed he had not done anything reflecting purposeful discrimination against any minority. In exercising the peremptory challenges, the prosecutor reviewed each prospective juror's questionnaire and did not appear affected by the particular juror's race or nationality during the individual questioning. No pattern of discrimination seemed to the trial court to be present. The prosecutor, having previously provided reasons for excusing prospective alternate jurors and RF, proceeded to state his reasons for excusing the other prospective jurors identified by defendant. The prosecutor believed that prospective juror GP was too anxious and immature to sit on the jury. GP did not appreciate the gravity of the situation, exhibited a willingness to excuse or justify any behavior, and in comments on her questionnaire noted there was a reason behind defendant's actions, whether or not they were justified. The prosecutor questioned the stability of prospective juror JN. Given the circumstances of the case, the prosecutor found it significant that during a period in his life when JN consumed alcoholic beverages, he had been violent and abusive toward his family, raising a doubt whether he would examine the evidence in a detached manner. JN appeared to conceal his actual views concerning the death penalty by offering a stock response to each of the prosecutor's questions, namely, that this was a sensitive case, and he would decide when the time comes. The prosecutor noted that prospective juror RH was merely 19 years of age. During the time jury selection was in progress, RH had visited her boyfriend in jail and had observed defendant. RH appeared to have a negative view of the death penalty because her mother had told her that only God can take a life. The prosecutor felt that prospective juror RN opposed the death penalty, and that this juror believed that no human had the right to take another person's life. RN had stated on the juror questionnaire that he had heard defendant killed his wife because he believed she was unfaithful to him. He had been on drugs and he was out of control. The prosecutor commented that if RN's was green, he could not sit on the jury. Defendant contends that the prosecutor's explanations did not rebut the presumption of group bias. Defendant urges that the prosecutor's reasons were insufficient, as a matter of law, were not supported by the record of the voir dire, and were inconsistent with the prosecutor's choices to retain on the jury persons having similar characteristics. We conclude to the contrary that the prosecutor's justifications were facially neutral, based upon specific or individual bias as opposed to group bias, similar to or the same as justifications we have upheld in other cases, and supported by the record of the voir dire. Accordingly, we reject defendant's claims. As an initial matter, we note that several of those excused regular prospective jurors RH and RN and prospective alternate jurors and RF held substantially negative views regarding the death penalty. A prosecutor may exercise peremptory challenges against prospective jurors who are not so intractably opposed to the death penalty that they are subject to challenge for cause under the Witt-Wainwright standard, but who nonetheless are substantially opposed to the death penalty. In other respects, the excused prospective jurors embodied characteristics or communicated views that justified the prosecutor's exercise of peremptory challenges. Prospective juror GP's answers during voir dire confirm that she lacked the maturity to act as a juror in the present case, as reflected by her focus on the attention she had received at work because of the possibility she would be selected as a juror in this case, and on the valuable experience she might acquire as a result. GP explained that she was a legal assistant secretary and was taking classes for certification in that field. When asked precisely how she would feel about having someone else's life in her hands, GP's enthusiastic and generalized response did not reflect she appreciated the gravity of that responsibility. GP was not reluctant to decide whether somebody will live or die and felt comfortable with that role. See People v. Sims, upholding peremptory challenge based upon prospective juror's immaturity. Prospective juror J.N., who volunteered extensive information related to his history of alcoholism, reasonably was excused on the basis that his life, experiences including his court-martial and his excessive alcohol consumption, resulting in abusive behavior toward his family, might predispose him to bias in favor of the accused. The record also confirms the prosecutor's explanation that J.N. was less than direct in responding to questions related to his views regarding the death penalty, finding excusal valid based upon the prospective juror's manner of answering questions. The record of prospective juror R.H.'s views concerning the death penalty, reflecting that her mother raised her to believe that only God can decide who lives and who dies, and that she did not feel that the death penalty is right, confirms the prosecutor's comments. R.H.'s relative youth and related immaturity were reasonable grounds for her excusal. R.H.'s relationship and contact with an incarcerated individual were appropriate grounds for excusal. A negative experience with police or the arrest of a prospective juror or a close relative is a gender-neutral reason for exclusion. Although the record of prospective juror R.N.'s voir dire reflects his assertion that he could return a death verdict if the facts so warranted, his statement on his juror questionnaire that no human has the right to take another's life could cause the prosecutor legitimate concern about R.N.'s ability to vote in favor of the death penalty. When R.N. was asked during voir dire what he recalled hearing about defendant's case, R.N.'s description of the information he had received, including that drugs were involved and that defendant's wife was unfaithful to him, was consistent with the prosecutor's stated concern, based on R.N.'s questionnaire responses, that R.N. might feel these circumstances justified or mitigated defendant's actions. For the first time on appeal, the defendant identifies 8 jurors, each of whom ultimately sat on the jury panel, who he contends gave responses materially similar to those given by certain prospective jurors the prosecutor excused. Although we previously have declined to engage in comparative juror analysis as an initial matter on appeal, in Miller LV the High Court examined the veracity of the prosecutor's stated race-neutral reasons for the challenged excusals notwithstanding a similar absence of comparative analysis at trial. Following that decision, we have assumed without deciding that we must undertake comparative juror analysis in these circumstances. The High Court engaged in that practice, and we shall do so the same. We compare the responses of the challenged prospective jurors with those of several jurors who served and, according to defendant, did not respond in a manner materially different from that of the challenged jurors, and who shared characteristics with those challenged. However, that exercise does not persuade us that the prosecutor's challenges were based on race or ethnicity, rather than specific bona fide reasons. Defendant suggests that in explaining her opposition to the death penalty based upon her mother's admonition that only God can take a life, prospective juror R.H.'s response was not materially different from those of sitting jurors A.A., J.M., and C.M. These jurors did not answer questions concerning the death penalty in a manner suggesting it was not their place to make a life or death decision, or reflecting the strong influence of a close relative, as R.H. did in relating her mother's general admonition and the juror's specific opinion that defendant should not receive the death penalty. A.A. indicated that it would take a grave crime for her to punish someone with death, and that she could vote for the death penalty if the crime was sufficiently severe, heinous, and vicious. J.M. indicated she would vote for the death penalty if the issue were presented to the voters in a referendum election, and she felt We have the best judicial system in the world, much more fair than most. In contrast to RH, who visited her boyfriend in jail, CM had numerous ties to law enforcement, and her husband was a former prosecutor. CM felt the death penalty was needed for some crimes, and hopefully some crimes would not be committed, if the criminal knew the consequences. Prospective juror JN was excused on the basis that he had been violent and abusive to his family during a period when he was drinking, was of doubtful stability, and was not direct in explaining his views regarding the death penalty. Defendant suggests that prospective juror JN did not give responses that were materially different from jurors DD, DH, and DA, and alternate juror VB, who indicated that incidents arising from alcohol or drug use had occurred in their families. These jurors were more forthcoming as to their views concerning the death penalty. They did not have a lengthy personal history involving alcohol abuse related to violence with family members or changes in personality. They did not state that persons consuming alcohol or drugs sometimes behave like an animal. As did JNA's, the defendant observes, prospective juror RN stated he could sit on the jury and return a death penalty if appropriate, and referred to the rule of an eye for an eye. RN also expressed reservations concerning the death penalty and referred to the biblical prohibition against killing. RN disclosed he had observed defendant in handcuffs during his televised statement after his arrest, and learned from news accounts that defendant's wife had been unfaithful to him. Defendant suggests that RN's responses were not materially different from those of jurors AA and JT, relating to the death penalty and to their knowledge of the circumstances of the case, because their responses also indicated that defendant may have been on drugs or may not have been in his right mind. AA, who was employed in the Child Support Division of the District Attorney's Office, stated she accepted the death penalty. Her answers did not suggest that circumstances such as the consumption of drugs or infidelity might justify or mitigate the conduct about which she had heard. JT said she thought, God has put people on earth to be judges, and that's one of the things that he may have called people to do, and if that's called for about the death penalty, then I think I must do that. She also stated that if the evidence proved defendant had committed the murders, it did not make much difference why he had done so. These responses were not materially similar to those of RN. Defendant points out that prospective alternate juror MM, in addition to indicating she could not imagine a crime in which she would find the death penalty appropriate, also stated she could consider the death penalty and was not unequivocally opposed to it, and could be a fair and impartial juror. Her statements, considered in total, reflected far more vigorous opposition to the death penalty than those of the sitting jurors or alternate jurors. Defendant indicates similarly that prospective alternate juror RF responded to questions regarding his views concerning the death penalty in a manner much more equivocal than was suggested by the prosecutor, in excusing him because of opposition to the death penalty. Defendant also suggests that RF's responses had much in common with those of juror DA, who stated he had mixed feelings about, or was reluctant to impose, the death penalty. RF explained that he believed the death penalty is arbitrarily applied from state to state, that its imposition traumatizes the defendant's family, just as a defendant's crimes traumatize the victim's families, and that he would eliminate the death penalty were it within his power to do so. Those responses reflect a much more considered and profound opposition to the death penalty than those of DA, who did not have any sense what he would do if the death penalty were the subject of an election, and did not wish to, yet could, decide whether imposition of that punishment was appropriate. The responses of RF and DA on other subjects, such as respect for the opinions of mental health professionals on behavioral motivation, also were dissimilar. Defendant suggests that prospective juror GP's responses do not support the prosecutor's assessment that she was too anxious, immature, and insufficiently aware of her responsibility to serve as a juror in the present case. As discussed above, GP's responses, in light of her background, confirm she was unsuitable for the grave responsibility of becoming a juror in the present case. The jurors chosen displayed a much greater ability to decide guilt and, if necessary, punishment carefully and fairly, and did not emphasize that the prospect of becoming a juror provided an opportunity for personal growth. Finally, Defendant claims the trial court failed in its duty to inquire and evaluate the prosecutor's explanations for the excusal of each prospective juror by determining whether a valid reason existed that actually prompted the prosecutor's exercise of the particular peremptory challenge. As explained above, the trial court denied the defense motion because the defendant failed to make a prima facie case. Therefore, the prosecutor was not required to provide reasons for his challenges, nor was the court needed to determine the validity and sincerity of any proffered reasons. Our assumption on appeal that a prima facie case was made does not alter the trial court's duties at trial. Moreover, as described above, during the hearing on the Wheeler-Batson motion, the trial court placed on the record its observations that the prosecutor had not exercised challenges or otherwise conducted himself in a manner suggesting any discriminatory motive. After the prosecutor stated his reasons, the trial court reiterated that defendant had failed to make a prima facie case, but also noted, the prosecutor has a rational basis for each of these peremptories. We find no Batson at Wheeler error. The prosecution's peremptory challenges of death penalty skeptics. Defendant contends that despite his objections, the prosecution utilized its peremptory challenges systematically to excuse prospective jurors who, although not unalterably opposed to the death penalty, nonetheless expressed skepticism concerning that punishment. Defendant identifies prospective jurors BH, AN, DC, and JF, asserting that the removal of these jurors violated his federal and state rights to due process of law, equal protection of the laws, an impartial jury drawn from a fair cross-section of the community, and a reliable determination of his guilt and appropriate penalty. As the defendant recognizes, we have rejected this claim numerous times. Skepticism about the death penalty is a permissible basis for a prosecutor's exercise of a peremptory challenge. The defendant does not offer any compelling reason to depart from our precedent, and we reject this claim, as we have in past cases. Motion for discovery of personnel files of DEA agent and officers present during defendant's arrest and return to the United States before trial. Defendant moved under Pitchess v. Superior Court for discovery of the personnel files of the law enforcement officials present during defendant's return flight from Mexico to the United States, in which he made incriminating statements. Defendant sought the files of Sonoma County Sheriff's detectives David Edmonds, Larry Doherty, Frank Trejo, Dave Sederholm, and Mike Brown, and LAPD officer Arturo Zorilla, as well as the files of DEA agent Joseph Martinez, who was not present on that flight. In a separate motion, defendant sought the personnel files of DEA agent Martinez, who was present at defendant's arrest. In the motion, defendant asserted on information and belief that the manner in which the United States and Mexican federal agents obtained this original statement suggests a pattern of selective harassing conduct and coercive practices by the above-named DEA agent over that required by an agent to carry out the duties of his office. At the hearing on the motion, the prosecutor stated that neither the Sonoma County Council nor the Los Angeles City Attorney could represent the DEA regarding Agent Martinez, that the District Attorney's Office had requested Martinez's personnel records through the United States Department of Justice, but that the request was denied because it was DEA policy to release personnel records only on order of a court having competent jurisdiction. The responses to defendant's motion also pointed out that, unlike the other officers whose personnel files had been sought, Agent Martinez was not on the return flight with defendant. In addition, the issue concerning statements made by defendant to Mexican officials in the presence of Agent Martinez had been litigated previously in the context of the hearing on the voluntariness of defendant's confession, and Martinez had been cross-examined at that time concerning his role. The trial court granted the motion about the personnel records of the officials present during the defendant's return flight and examined those records in camera, finding that none should be released. The trial court indicated that Agent Martinez did not have jurisdiction to order the United States Attorney into court, could not enter an ex parte order without counsel, and lacked authority to produce records. Defendant contends the trial court erred in failing to order discovery of the records of Agent Martinez. On a showing of good cause, a criminal defendant is entitled to discovery of relevant documents or information in the personnel records of a police officer accused of misconduct against the defendant, to determine whether the reasonable cause requirement has been met. A trial court must consider whether the defense has established 1. That the information is material to the subject matter of the pending litigation, and 2. A reasonable belief that the agency has the type of information sought. The defense must demonstrate a logical connection between the charges and the proposed defense, and also articulate how the discovery being sought would support such a defense or how it would impeach the officer's version of events. Garcia v. Superior Court. The information sought must be described with some specificity to ensure that the defendant's request is confined to the instances of officer misconduct related to what has been claimed by the defendant. EBID. The trial court did not abuse its discretion in denying the discovery motion as to Agent Martinez. As discussed above, when the voluntariness of defendant's confession previously was litigated, defendant's statements were found to be voluntary. In connection with those proceedings, the circumstances of defendant's arrest and transportation to Mexico City in the custody of Mexican officials also had been explored. It was established that Agent Martinez was present but did not participate in the arrest, that he told the foreign officials to treat defendant well and not question him, that defendant had not been abused while in Mexican custody, and that the failure of foreign officials to advise defendant of his Miranda rights had not affected the statements he made to American officials. Admission of evidence suggesting that defendant molested the Richards girls. Defendant contends the trial court erred in admitting evidence establishing that the victims Ruth and Marie Richards were sexually molested at the time of the murders. The challenged evidence included 1. The portion of defendant's tape-recorded account of the murders when he was asked concerning and vigorously denied committing any sexual crimes about these victims. 2. The testimony of an evidence technician and of a sheriff's deputy who first arrived at the Richards crime scene concerning the positions and condition of the bodies. And 3. The victim's bloody underpants. At the guilt phase, a single photograph depicting victim Ruth Richards at the scene lying prone, with her legs spread apart, underpants wrapped around one ankle, a bloody handprint on her buttocks, and blood smears consistent with the body having been moved, also was admitted into evidence. At the penalty phase, a similar photograph of Marie Richards was admitted into evidence. Defendant's claim as it relates to that evidence is discussed below. At trial, the defense attempted to eliminate or reduce the impact of evidence suggesting any sexual misconduct with these victims. The defense moved in limine to exclude photographic proof of suggestive positioning of the bodies. It was successful to the extent of limiting the admission of the photographs to the 2 described above. The defense moved to redact the portion of defendant's tape-recorded interview and confession concerning removal of the victim's underwear and the presence of bloody handprints on their legs and thighs, to exclude the evidence of the victim's bloody underpants, and twice requested a mistrial during the prosecutor's examination of the evidence technician, who was asked to describe the condition of the bodies by referring to additional photographs not permitted to be shown directly to the jury. These motions were denied. Defendant asserts the evidence was irrelevant to any material issue of disputed fact, observing that at trial he offered to stipulate to the admission of evidence relating to the positions and condition of the bodies. Relevant evidence is that, having any tendency and reason to prove or disprove any disputed fact that is of consequence to the determination of an action, and that bearing on the defendant's account of events and state of mind. Here the evidence also tended to establish defendant's attitude toward his victims, and that he acted methodically and deliberately rather than as the result of uncontrollable impulses arising from his ingestion of drugs and alcohol. In addition, the prosecution is not required to accept a stipulation if the effect would be to deprive the state's case of its effectiveness and thoroughness, nor is it obligated to present its case in the sanitized fashion suggested by the defense. The prosecutor need not stipulate to proof in place of photographic evidence. Defendant also contends the trial court erred in failing to exclude the evidence as substantially more prejudicial than probative under Evidence Code Section 352 and to engage in the weighing process required by that statute. The circumstance that evidence is adverse to a defendant's case does not render it prejudicial within the meaning of Section 352. In applying this statute, we evaluate the risk of undue prejudice, that is, evidence which uniquely tends to evoke an emotional bias against the defendant as an individual and which has minimal effect on the issues, not the prejudice that naturally flows from relevant, highly probative evidence. In particular, we have rejected the claim that the sexually suggestive nature of photographs of a murder victim created undue prejudice because it was the nature of the crime that made it necessary for the jury to see her without clothes. In the present case, the trial court carefully restricted the photographic evidence of the victims and limited presentation of the crime scene details, mainly to the information provided through witnesses such as the evidence technician who referred to photographs not exhibited to the jurors. It is evident the trial court weighed the prejudicial impact of that and other evidence against its probative value, determining the evidence was admissible. Having reviewed the photographic evidence in question, we conclude the trial court did not abuse its discretion in determining that the risk of undue prejudice from its admission did not substantially outweigh its probative value. Defendant suggests the jurors must have assigned undue weight to Detective David Edmonds' statement during his in-flight interview with defendant that Edmonds believed defendant molested these victims. In the context of the jury's consideration of defendant's entire confession, we conclude Edmonds' comments reflect nothing more than appropriate questioning regarding defendant's account of the crimes and could not have had any undue impact on the jury. 10. Admission of asserted victim impact evidence at the guilt phase. Defendant contends the trial court erred in admitting evidence establishing that the victims Ruth and Marie Richards were sexually molested at the time of the murders. The challenged evidence included 1. The portion of defendant's tape-recorded account of the murders when he was asked concerning and vigorously denied committing any sexual crimes about these victims. 2. The testimony of an evidence technician and of a sheriff's deputy who first arrived at the Richards crime scene concerning the positions and condition of the bodies. And 3. The victim's bloody underpants. At the guilt phase, a single photograph depicting victim Ruth Richards at the scene lying prone, with her legs spread apart, underpants wrapped around one ankle, a bloody handprint on her buttocks, and blood smears consistent with the body having been moved, also was admitted into evidence. At the penalty phase, a similar photograph of Marie Richards was admitted into evidence. Defendant's claim as it relates to that evidence is discussed below. At trial, the defense attempted to eliminate or reduce the impact of evidence suggesting any sexual misconduct with these victims. The defense moved in limine to exclude photographic proof of suggestive positioning of the bodies. It was successful to the extent of limiting the admission of the photographs to the 2 described above. The defense moved to redact the portion of defendant's tape-recorded interview and confession concerning removal of the victim's underwear and the presence of bloody handprints on their legs and thighs to exclude the evidence of the victim's bloody underpants, and twice requested a mistrial during the prosecutor's examination of the evidence technician, who was asked to describe the condition of the bodies by referring to additional photographs not permitted to be shown directly to the jury. These motions were denied. Defendant asserts the evidence was irrelevant to any material issue of disputed fact, observing that at trial he offered to stipulate to the admission of evidence relating to the positions and condition of the bodies. Relevant evidence is that, having any tendency and reason to prove or disprove any disputed fact that is of consequence to the determination of an action, and that bearing on the defendant's account of events and state of mind. Here the evidence also tended to establish defendant's attitude toward his victims and that he acted methodically and deliberately rather than as the result of uncontrollable impulses arising from his ingestion of drugs and alcohol. In addition, the prosecution is not required to accept a stipulation if the effect would be to deprive the state's case of its effectiveness and thoroughness, nor is it obligated to present its case in the sanitized fashion suggested by the defense. The prosecutor need not stipulate to proof in place of photographic evidence. Defendant also contends the trial court erred in failing to exclude the evidence as substantially more prejudicial than probative under Evidence Code Section 352 and to engage in the weighing process required by that statute. The circumstance that evidence is adverse to a defendant's case does not render it prejudicial within the meaning of Section 352. In applying this statute, we evaluate the risk of undue prejudice, that is, evidence which uniquely tends to evoke an emotional bias against the defendant as an individual and which has minimal effect on the issues, not the prejudice that naturally flows from relevant, highly probative evidence. In particular, we have rejected the claim that the sexually suggestive nature of photographs of a murder victim created undue prejudice because it was the nature of the crime that made it necessary for the jury to see her without clothes. In the present case, the trial court carefully restricted the photographic evidence of the victims and limited presentation of the crime scene details mainly to the information provided through witnesses such as the evidence technician who referred to photographs not exhibited to the jurors. It is evident the trial court weighed the prejudicial impact of that and other evidence against its probative value, determining the evidence was admissible. Having reviewed the photographic evidence in question, we conclude the trial court did not abuse its discretion in determining that the risk of undue prejudice from its admission did not substantially outweigh its probative value. Defendant suggests the jurors must have assigned undue weight to Detective David Edmonds' statement during his in-flight interview with defendant that Edmonds believed defendant molested these victims. In the context of the jury's consideration of defendant's entire confession, we conclude Edmonds' comments reflect nothing more than appropriate questioning regarding defendant's account of the crimes and could not have had any undue impact on the jury. 10. Admission of asserted victim impact evidence at the guilt phase. A single photograph depicting victim Ruth Richards at the scene lying prone, with her legs spread apart, underpants wrapped around one ankle, a bloody handprint on her buttocks, and blood smears consistent with the body having been moved, also was admitted into evidence. At the penalty phase, a similar photograph of Marie Richards was admitted into evidence. Defendant's claim as it relates to that evidence is discussed below. At trial, the defense attempted to eliminate or reduce the impact of evidence suggesting any sexual misconduct with these victims. The defense moved in limine to exclude photographic proof of suggestive positioning of the bodies. It was successful to the extent of limiting the admission of the photographs to the two described above. The defense moved to redact the portion of defendant's tape-recorded interview and confession concerning removal of the victim's underwear and the presence of bloody handprints on their legs and thighs to exclude the evidence of the victim's bloody underpants, and twice requested a mistrial during the prosecutor's examination of the evidence technician, who was asked to describe the condition of the bodies by referring to additional photographs not permitted to be shown directly to the jury. These motions were denied. Defendant asserts the evidence was irrelevant to any material issue of disputed fact, observing that at trial he offered to stipulate to the admission of evidence relating to the positions and condition of the bodies. Relevant evidence is that, having any tendency and reason to prove or disprove any disputed fact that is of consequence to the determination of an action, and that bearing on the defendant's account of events and state of mind. Here the evidence also tended to establish defendant's attitude toward his victims and that he acted methodically and deliberately rather than as the result of uncontrollable impulses arising from his ingestion of drugs and alcohol. In addition, the prosecution is not required to accept a stipulation if the effect would be to deprive the state's case of its effectiveness and thoroughness, nor is it obligated to present its case in the sanitized fashion suggested by the defense. The prosecutor need not stipulate to proof in place of photographic evidence. Defendant also contends the trial court erred in failing to exclude the evidence as substantially more prejudicial than probative under Evidence Code Section 352 and to engage in the weighing process required by that statute. The circumstance that evidence is adverse to a defendant's case does not render it prejudicial within the meaning of Section 352. In applying this statute, we evaluate the risk of undue prejudice, that is, evidence which uniquely tends to evoke an emotional bias against the defendant as an individual and which has minimal effect on the issues, not the prejudice that naturally flows from relevant, highly probative evidence. In particular, we have rejected the claim that the sexually suggestive nature of photographs of a murder victim created undue prejudice, because it was the nature of the crime that made it necessary for the jury to see her without clothes. In the present case, the trial court carefully restricted the photographic evidence of the victims and limited presentation of the crime scene details mainly to the information provided through witnesses, such as the evidence technician, who referred to photographs not exhibited to the jurors. It is evident the trial court weighed the prejudicial impact of that and other evidence against its probative value, determining the evidence was admissible. Having reviewed the photographic evidence in question, we conclude the trial court did not abuse its discretion in determining that the risk of undue prejudice from its admission did not substantially outweigh its probative value. Defendant suggests the jurors must have assigned undue weight to Detective David Edmonds' statement during his in-flight interview with defendant that Edmonds believed defendant molested these victims. In the context of the jury's consideration of defendant's entire confession, we conclude Edmonds' comments reflect nothing more than appropriate questioning regarding defendant's account of the crimes and could not have had any undue impact on the jury. 10. Admission of asserted victim impact evidence at the guilt phase. Defendant contends the trial court erred in admitting the testimony of victim Tracy Tuvey's wife, Catherine. Defendant asserts that her testimony was irrelevant, substantially more prejudicial than probative, and thus inadmissible under Evidence Code Section 352, that it amounted to victim impact evidence inadmissible at the guilt phase, and that its admission at that phase violated defendant's right to due process of law under the 14th Amendment to the Federal Constitution. Prior to commencement of the guilt phase, the defense offered to stipulate to any facts to which Catherine Tuvey might testify because she had been highly emotional in testifying at the preliminary hearing. The defense suggested the prosecutor intended to present her testimony, which would be cumulative from that other witnesses provided, solely to inflame the jury. The prosecutor argued that Mrs. Tuvey's testimony was necessary to identify her husband and describe his actions on the morning he was murdered. Following a colloquy between the trial court and the prosecutor regarding this potential testimony, the court indicated Mrs. Tuvey's testimony was unnecessary to establish Tuvey's identity. After the prosecutor reiterated that the testimony would approve the time of Tuvey's departure and other relevant times, the court required the prosecutor to offer proof before calling her to testify. In his subsequent offer of proof, the prosecutor explained Mrs. Tuvey would identify this victim as her husband and further testify that he departed for work 10 minutes before 8 a.m. on the day of the murder, that his drive from their residence to Grand Cru Vineyard was approximately 5 minutes in duration, and that recently he had been leaving for work an hour earlier than in the past, which was relevant because in his confession, defendant stated he knew Tuvey had been going to work an hour earlier. The prosecutor said that because the trial court had denied his motion to introduce Tuvey's autopsy photographs, Mrs. Tuvey's testimony was necessary to identify her husband and his automobile as depicted in an aerial photograph of the crime. Scene defense counsel then offered to stipulate those facts to avoid the possibility that Mrs. Tuvey would break down on the witness stand, as she had at the earlier hearing, thereby creating undue sympathy for the victim's family and prejudicing the defense. The prosecutor then explained to the court that at the preliminary hearing, when he returned to counsel's table, he inadvertently had left an autopsy photograph in front of Mrs. Tuvey on the witness stand, and the prosecutor did not intend to show the picture to her at trial or expect her to have the same reaction. In response, defense counsel argued the testimony was highly prejudicial victim impact evidence. The trial court observed the testimony in question was cumulative and potentially highly prejudicial, and reserved its ruling pending the prosecution's presentation of other evidence on those issues. When the prosecutor approached the conclusion of his case in chief, he requested a ruling on the issue of Mrs. Tuvey's intended testimony. Defense counsel objected on undue prejudice under Evidence Code Section 352 and violation of due process under the federal Constitution, and repeated his offer to stipulate to the evidence in question. The prosecution reiterated its offer of proof and stated that, in addition, Mrs. Tuvey would testify she was aware of the tension or difficulty that existed between her husband and defendant. The prosecutor said Mrs. Tuvey would not break down and become emotional on the witness stand. The trial court then overruled the defense objection. Mrs. Tuvey proceeded to testify concerning the time her husband departed for work, explaining that he had recently been reporting to work and leaving from work an hour earlier than before to pick up their daughter after school, so that Mrs. Tuvey would not have to drive during her pregnancy. Mrs. Tuvey identified her husband in the aerial photograph. She testified she was aware of a conflict between her husband and defendant and explained that defendant had some ability to speak English. She did not become emotional on the witness stand. Defendant contends this evidence was irrelevant and inadmissible in view of the circumstance that defendant offered to stipulate to the substance of Mrs. Tuvey's testimony. That testimony, however, was relevant to the credibility and reliability of various witnesses and defendant, whose account of events and his state of mind were at issue. As indicated above, the prosecution is not required to accept a stipulation. That would deprive its case of its effectiveness or present its case in the manner preferred by the defense. Garceau Supra 6 Calum 4th at P. Defendant also asserts Mrs. Tuvey's testimony, recounting the last time she saw her husband alive, likely would inflame the emotions of the jury, as would her demeanor, and thus was substantially more prejudicial than probative under Evidence Code Section 352. The trial court correctly determined that her testimony did not create undue prejudice in its substance or presentation. The court deferred ruling on the admissibility of this testimony to consider whether it was necessary in light of other evidence, restricted the prosecutor's display of photographs relating to the evidence in question, and secured the prosecutor's promise the witness would not suffer an emotional breakdown during her testimony. Defense counsel objected on undue prejudice under Evidence Code Section 352 and violation of due process under the federal Constitution, and repeated his offer to stipulate to the evidence in question. The prosecution reiterated its offer of proof and stated that, in addition, Mrs. Tuvey would testify she was aware of the tension or difficulty that existed between her husband and defendant. The prosecutor said Mrs. Tuvey would not break down and become emotional on the witness stand. The trial court then overruled the defense objection. Mrs. Tuvey proceeded to testify concerning the time her husband departed for work, explaining that he had recently been reporting to work and leaving from work an hour earlier than before to pick up their daughter after school, so that Mrs. Tuvey would not have to drive during her pregnancy. Mrs. Tuvey identified her husband in the aerial photograph. She testified she was aware of a conflict between her husband and defendant and explained that defendant had some ability to speak English. She did not become emotional on the witness stand. Defendant contends this evidence was irrelevant and inadmissible in view of the circumstance that defendant offered to stipulate to the substance of Mrs. Tuvey's testimony. That testimony, however, was relevant to the credibility and reliability of various witnesses and defendant, whose account of events and his state of mind were at issue. As indicated above, the prosecution is not required to accept a stipulation. That would deprive its case of its effectiveness or present its case in the manner preferred by the defense. Garceau Supra 6 Cal 4th at P. Defendant also asserts Mrs. Tuvey's testimony recounting the last time she saw her husband alive likely would inflame the emotions of the jury, as would her demeanor, and thus was substantially more prejudicial than probative under Evidence Code Section 352. The trial court correctly determined that her testimony did not create undue prejudice in its substance or presentation. The court deferred ruling on the admissibility of this testimony to consider whether it was necessary in light of other evidence, restricted the prosecutor's display of photographs relating to the evidence in question, and secured the prosecutor's promise the witness would not suffer an emotional breakdown during her testimony. Mrs. Tuvey's account of her husband's departure and her identification of him in the aerial crime scene photograph scarcely would, evoke an exceptional emotional bias against defendant as an individual. Defendant also urges that introduction of this testimony amounted to victim impact evidence that is inadmissible at the guilt phase. We have recognized that a prosecutor's argument to the jury that appeals to sympathy for the victim is out of place during an objective determination of guilt. Similarly, the prosecutor's introduction of victim impact testimony is impermissible at the guilt phase of a capital trial. In the present case, however, Mrs. Tuvi's testimony scarcely touched upon the victim's family life and did not relate the effect of defendant's acts upon family members. At the guilt phase, physician's testimony regarding the extent of the victim's injuries was not victim impact. Evidence? At the penalty phase, family members' testimony concerning the various ways they adversely were affected by loss of the victim's care and companionship was admissible victim impact evidence. At the penalty phase, the mother of the victim testified the victim was her only daughter, whose murder left the victim's young son motherless. Defendant asserts nonetheless that the admission of this testimony infected the trial's guilt and penalty phases in violation of defendant's federal constitutional rights. The High Court overruled those decisions, holding that a state can determine that victim impact evidence demonstrating specific harm caused by the defendant's crimes is relevant to a jury's assessment of a defendant's moral culpability. Ex post facto principles are not violated by applying the Payne rule to cases where the crimes precede that decision. Under our law, evidence of specific harm, including the impact on the victim's family caused by the defendant's acts, is a crime circumstance and is therefore admissible under Section 190.3 Factor A. In the event the jury at the penalty phase considered Mrs. Tuvi's brief guilt phase testimony concerning her husband, the jurors were entitled to consider that and all other circumstances of the crimes. Prosecutorial misconduct affecting right to a fair trial at both phases of the proceedings. Defendant raises several claims of prosecutorial misconduct in the misuse of voir dire in commenting upon defendant's failure to testify, in indoctrinating potential jurors, proffering evidence of defendant's sexual misconduct with the Richards girls, and impugning the motives of defense counsel and a defense expert. Before examining these claims, we recall the general principles governing a prosecutor's conduct during trial in the context of a claim of prosecutorial misconduct. A prosecutor who uses deceptive or reprehensible methods to persuade the jury commits misconduct, and such actions require reversal under the federal Constitution when they infect the trial with such unfairness as to make the resulting conviction a denial of due process. A defendant may not complain on appeal of prosecutorial misconduct unless in a timely fashion, and on the same ground the defendant objected to the action and also requested that the jury be admonished to disregard the perceived impropriety. A defendant whose counsel did not object at trial to alleged prosecutorial misconduct can argue on appeal that counsel's inaction violated the defendant's constitutional right to the effective assistance of counsel. But the appellate record rarely demonstrates that the failure to object was the result of counsel's incompetence. Generally, such claims are more appropriately litigated on habeas corpus, which allows for an evidentiary hearing where the reasons for defense counsel's actions or omissions can be explored. A. Voir dire. Assertion that defendant was the best source of his state of mind. Defendant contends that the prosecutor committed misconduct by repeatedly questioning potential jurors during voir dire and by recalling those questions during closing argument in a manner designed to emphasize that jurors should consider defendant's statements to be the best source of his state of mind during the commission of the murders. Defendant asserts the prosecutor thereby committed error under Griffin v. California and also impermissibly attempted to indoctrinate the jury to discount expert testimony concerning defendant's mental state. In the course of general voir dire, during which 3 of the jurors who eventually served on the case were present, DD, DH, and JM, the prosecutor posed questions to several potential jurors relating to whether on a particular date the potential juror, or instead someone else, would have been the best source of information concerning that potential juror's state of mind, suggesting in effect that the best source would be the potential juror themselves. After a prospective juror, who did not serve on the jury, asked for clarification, the prosecutor indicated, "The best the question is obviously going to be not, psych, what's in my mind or your mind at any given time during this trial, but what was in Mr. Salcido's mind." The prospective juror then commented that defendant was not on the witness list. The trial court explained that this circumstance did not necessarily signify defendant would not testify as a witness. After further exchange with the prospective juror on a different topic, the prosecutor indicated that the question he was trying to ask was that if people give opinions about what other people are thinking at a given moment, and what I'm raising to you is that we should look with some caution about those kinds of opinions, and if we have available to us more direct evidence perhaps of what a person is feeling or what a person did, and why they did it, then we ought to look to that as well. So that's all I'm trying to get at. After the voir dire of prospective jurors concluded for the day, the trial court and counsel outside the jury's presence discussed scheduling and evidentiary issues. At that point, defense counsel objected to the foregoing questioning by the prosecutor as improper comment on defendant's failure to testify in violation of Griffin, and requested that the trial court instruct the prosecutor from now on not to inquire as to who is the best judge of what was going on in defendant's mind. The trial court cautioned the prosecutor against arguing his case in voir dire, and the prosecutor agreed to phrase his questions more accurately. It is apparent that defendant failed to timely object during voir dire to the prosecutor's line of questioning and thus has forfeited this claim on appeal. Moreover, in response to defendant's belated objection and request, the trial court instructed the prosecutor to refrain from questioning any additional potential jurors in that manner. The prosecutor did not press the matter in closing argument. Finally, the prosecutor's questions do not reflect that his sole purpose was indoctrinating the potential jurors. B. Voir dire, additional indoctrination of the jury defendant, asserts that the prosecutor otherwise attempted to indoctrinate potential jurors by questioning them regarding their experiences relating to alcohol consumption, specifically about its effect on their capacity to make decisions. This questioning did not improperly attempt to educate potential jurors concerning the facts of the case or to secure their votes, and thus was proper. C. Proffer of unredacted statements and evidence of sexual misconduct. Defendant contends that the prosecutor introduced grossly inflammatory evidence of defendant's sexual misconduct with the Richards girls. As explained above, the testimony and related evidence properly were admitted. Impugning defense counsel and defense expert defendant contends the prosecutor impugned the motives of defense expert Dr. Crinella by, among other things, suggesting his testimony resulted from his long friendship with defense counsel. Defendant forfeited his present claim of prosecutorial misconduct by failing to object at trial and seek an admonition. S., a specialist in psychopharmacology, testified regarding the effects of alcohol and cocaine consumption. Dr. Jones explained that a cocaine user does not necessarily appear or act intoxicate by impairment of motor performance, and in moderate doses, cocaine may enhance mental function, whereas alcohol has the opposite effect. Alcohol and cocaine, although operating in opposite manners on the user, tend to elicit their innate behavior and traits. Dr. Jones reviewed the police and toxicology reports, listened to a TA recording of the defendant's confession, and was advised of the foregoing test results of the analysis of the dried blood sample. Dr. Jones stated that if high dosages of cocaine repeatedly had been ingested, he would expect to find 500 to 1,000 nanograms of coca analysis bolite per gram of blood. Dr. Jones also testified that the type of weapon select by an assailant and the efficiency with which a wound is inflicted tend to indicate the amount of plan involved in an attack. Lying to a victim to induce that person to move to a different spot, such as the defendants lying to Mrs. Richards and killing TE children one at a time, were acts that were consistent with planning rather than with impulsive or disorganized thinking. The defendant's ability to travel from one crime scene to another reflected attention, concentration, and planning inconsistent with the mental impairment that would result from heavy drug usage. The defense case here. Defendants. History and socialization. The defense presented testimony regarding the defendant's emigration from Mexico and the various circumstances that frustrated his attempts to assimilate into the United States. Alex Zaragoza and professed defendants RI in the Department of Ethnic Studies at the University of California, Berkeley, reviewed the police reports and spoke with the defendant on several occasions. Zaragoza formed the opinion that defendant exaggerated his importance, blamed others for his failures, had a poor defendant of D had defendant for esteem. Zaragoza found the defendantal history. Defendant in every respects. Defendant's relationship with his family was reigned. He left Mexico after threatening to kill his entire family and moved to Northern California without THR assistance. Returning to his hometown, he boasted of his achievements in the United States. Defendant's experience a Mexican immigrant was atypical. In Sonoma, defendant had many non-Mexican acquaintances and frequented Anglo-American bars. He portrayed the defendants in Mexico as more affluent and accomplished than their actual circumstances. According to Zaragoza, the defendant's merit history was out of ordinary. His first marriage to a woman pregnant by another man was not typical in Mexican culture. The defendant married a con-time in the United States, and it was unclear whether his wife Deborah's baby was the defendant's biological hild. The defendant belatedly learned that his third wife, Angela, had borne a child who was not the defendant's. Angela was an unusual choice as the defendant's marital partner in other ECTs. She had been educated at home because her family believed the public schools were a bad influence, was taught feminine tasks, and was raised as a strict cat lee. In Zaragoza's view, Angela rebelled by, among other things, marrying a Mexican immigrant to the displeasure her family. Angela became independent during the marriage, behavior that was inconsistent with a wife's